do I have and how do I deal with it? Destruction of information. What the Privacy Act says is that if you collect personal information for a specific purpose, then you should destroy that information once the purpose is complete. I don't think there are many businesses out there that actually do that. I know for a fact that you join up with a telecommunications provider and they, even though you might stop using them, and 5 years later you come back and they still have your client records. Now, I don't understand how that's not a breach of the Privacy Act. Their argument is, oh, it's for the purpose of providing services. Well, hey, I haven't been your client for 5 years. How the hell can it be part of providing me services? So there's going to be a little bit of, or I anticipate that there's going to be a little bit of argy-bargy around that. Destruction of information, a lot of people are stuck on this. There are different rules and different obligations. A pretty good rule of thumb is 7 years. 7 years, the tax office has pulled it back to about 5 because I don't think they have the resources to chase everybody for back in 7 years. But 7 years is probably a good rule of thumb. There's a huge number of pieces of legislation that deal with the periods of time that you should retain information before destroying it. It's a much more sort of narrow issue and is relevant to your specific circumstances, so we won't go into it in detail, but just be aware that you probably should have something in place, and it'll help you manage your materials as well. Basic compliance, you do need to understand your ICT system. So ICT is information and communication technology. You need to know the basics around what security systems you have in place. So if you outsource it to a service provider and they look after all your IT, you want to know from them what are the security systems in place around that information. How do I know that it can't be just hacked and easily or accessed easily? Now, this is hilarious because it doesn't even have to be a technology system. Vodafone or one of the telephone providers got in trouble because they did an ad on TV, and in the background in the ad was a whiteboard with a whole bunch of phone numbers on it and people's names, and clearly they didn't realize that it was there and on screen throughout the whether it was an interview or whatever it was on TV, but it went all over TV. They had to do some fairly serious apologising around that and put some systems in place and contact all of the people who were impacted by that. So it is really about understanding your own systems. Okay, we've got another little poll here, if I can find it. And the poll is, could you handle a privacy complaint? Would you know what to do if somebody contacted you and said, hey, I believe you've misused my personal information? Whoa, we got people voting quickly this time. Okay, give that 5 more seconds. 3, 2, 1. Okay, about 30% of you have said yes, you do know how you would manage a privacy complaint, and around 70% have said no, you wouldn't know. Now that's what your privacy procedures are about. It's how do you deal with a complaint that comes in line with your policy. Okay, moving right along. Now we've got, just so you know, I've got about 4 or 5 more slides to go and then questions. So I'm aiming to get this done in the next 15 minutes, including your questions. All right, your risk profiles, what we're talking about here is whether you are seriously facing big fines or not. Now the fines are starting at around $300,000 for individuals. So if you're a sole trader, that's the kind of potential you're looking at if you're not handling personal information correctly. If you've got a company, then the fines are, up to $1.7 million. Nothing to sneeze at. Now, a low-risk activity is if you're not actively out there soliciting information, so you don't have a web capture or a name capture on your website, you are receiving emails, maybe not such a big deal, but you're not actually out there actively asking for or collecting personal information. That's a low-risk profile. You've got a medium risk profile if you are using a web form to collect a name and email address and building a list. If you've got a reasonably small list, and I'm talking, say, under 1,000 people, and you're not doing direct marketing. So you might just be sending out a newsletter, and there might be a little bit of marketing in your newsletter, but the newsletter is more an information source than a marketing source. Now, you're high risk if you have a good-sized list, you do direct marketing, you are collecting personal information other than from the individual, and this is not collective. These are high risk if you do just one of these things. So collecting personal information other than from the individual is, for example, buying a list, going onto websites and grabbing email addresses, that sort of thing. If you're collecting sensitive information, particularly health information, then you're a higher risk profile. And if you're using overseas call centres or support staff, then you're a higher risk profile. And you need to get this stuff sorted out. So just quickly, I think I have one more poll. Oh, or maybe not. I might have just lost it. Okay. I was going to do a poll here and say, what risk profile do you think you are, whether you're low, medium or high? And I seem to have clicked the wrong button on the management screen and lost the polls, so sorry about that. If you do want to post a quick comment and let me know whether you think you're a high, low or medium risk profile. Okay, we got one high. High-ish, medium, low, excellent. High risk. Okay, fantastic. Thank you so much for putting in these comments. It's really great to get feedback when you're giving a presentation like this. I'm used to having an audience in front of me, and it's really easy to see how people are finding things, and to get your answers like this is great. Okay, so we've got a mixture of low, medium and high risk businesses. For a low risk profile, now I did say when I marketed this webinar that I would give you solutions, and here are your solutions. If you're a low risk profile, we've got a free download plugin. Now this is, the plugin's designed for WordPress websites, but the information is there that you can copy and paste into other web platforms if you're not using WordPress. So if you go into lawfulwebsites.info, you will be able to find that free plugin. We did have an issue today where somebody said it was not working, and we've corrected that issue, so you shouldn't have any problems downloading it. Okay, medium. If you're a medium risk profile, what I've done is put together we've got a website starter pack, and in that starter pack you have both a privacy policy and you have a procedure to back it up. So the procedure gives you the template for how you deal with privacy complaints, how you deal with storing information. Now it's not tailored to your business, but it is as general as I can make it and as applicable to as many businesses as possible. So if you're interested in that, go and have a look. Same website, lawfulwebsites.info, website starter pack will give you the policy and the procedure so that you at least know what you're doing with your information. High risk. If you're in a high-risk category, it's really worthwhile having a chat with me and going through this in a little bit more detail. So what I mean by this is I will send you a checklist or a questionnaire of a number of different things for you to give me information about what you do in your business. Then I'll have a look at the privacy policy you've got and the templates that I use. We'll tailor something that fits with what your business does, and we'll tailor the procedures to fit with what your business does, so that you're then confident moving forward that you've got it sorted before all these big fines come in. So they're the three different solutions, and they're based on what you do in your business. Okay, questions. Now I know that there were some questions back in the beginning that I haven't answered. So what we'll do is we'll work through the questions we've got really quickly. As a low risk, this is one of the questions that come in. Where do I stay updated with any changes to privacy and disclaimer law? Okay, disclaimers is risk management and it's more consumer protection than privacy. What you can do with consumer protection is consumer.gov.au is the government website. The information on there is good, it's general, but it'll keep you updated as to some of the things that are happening. With privacy, if you go to privacy.gov.au, again, that's the government website. It tells you what the Privacy Commissioner is up to and what is on their hit list at any given point in time. They do have some pretty good articles from time to time. Their website at the moment is still geared to the existing system as opposed to the new system, so they've got some updating information. I've given it a fairly good look over the last few weeks to make sure that it was accessible. I don't know that the information is terribly helpful for business in complying with the new laws just yet. I'm hoping that down the track that they'll come up with some more practical information. So there's two areas where you can have a look, the government websites. If you're an internet marketer, this is another one of the questions that have come up, and you acquire a list from overseas, are you infringing Australian privacy laws? Well, Australian privacy laws are about personal information for individuals. They don't differentiate as to where that individual lives. They differentiate as to where your business is situated. So if your business is in Australia and a complaint is made, even if it's from someone overseas, the fact is your business you're required to comply with the Australian privacy laws. If there's a complaint, you're still liable. So just be aware that just because the information's come from overseas, a complaint could still be made to the Commissioner and you could still be facing issues. It may not be an issue because people may not know the Commissioner exists, but with the accessibility of information on the internet, don't bet on it. Okay, I've got someone with a list of, say, 1,300 people. They send weekly newsletters with special offers, retail online, product-based service, product rather than service-based, and international. Is that a low, medium, or high risk? Well, I would suggest that you're in the higher risk category, particularly if you're relying on the income from that business, because you don't want to be put in a position where you're paying huge fines or you get stopped from a particular activity around your business because you're non-compliant. So that's another thing you've got to look at in terms of your business. Can you afford to lose it? And if you can't afford to lose it, then do what needs to be done to make sure that you are compliant. Now, we had some questions way back at the beginning. What about information that is captured as a screen save on social media, for example, Facebook, that could be used as testimonial evidence? Don't be using, if you grab somebody's comments from Facebook and you screenshot them and you use them as a testimonial, then you're not only potentially in breach of privacy laws, you're also potentially in breach of consumer protection laws. Because the consumer protection laws deal with testimonials, and what they say is the testimonial has to come from a real person, it has to be freely given, you need to have their permission, it needs to be current. So it may, if you're going to use what they've said as a testimonial, get them to send it to you separately with a date stamp and their authority to use it rather than screen capture it. Facebook has its own delightful set of rules and procedures. I haven't read them again recently. They change all of the time, and you may also potentially be in breach of Facebook rules. So you'd have to go and have a look at that as well. Okay. Now let's see, are there any other questions? I'm just trying to see through and see what I've missed. Okay. Sorry if there's anyone with more questions. I'm just scrolling up and down. Don't mean to leave you hanging. What if in your terms and conditions of, say, a competition, okay, the question is, what if they have agreed in the terms and conditions, e.g. of a competition, would that cover providing permission? The whole thing about getting permission is people have to know they're giving it. So you will be familiar with all the websites that say, tick a box if you read the terms and conditions and privacy policy. Travel websites are a great example. You can't actually book your airline flight unless you tick there, yes, I've read your terms and conditions. Now, if you're like most people, you don't ever bother to read them. I read them at least once. If they tell me they've made changes, then I might read them again. But I read them at least once. If you're going to ask somebody, if you're going to, what's happening now with competitions in particular is if somebody's personal information is going to be used for a purpose other than their entry into that competition, it has to be spelt out in order for you to protect yourself or to protect your business. So put it in your business and, put it in your promotion. We'd like your personal information, but make it a tick box option. Either tick box they've got to opt out or tick box they've got to opt in. In Australia you can do either way. If your audience is predominantly US, for example, then you need opt out as opposed to opt in. So you've got, opt in as opposed to opt out. So they've got to agree to go into your list as opposed to having to tick the box to get out of your list, if that makes sense. Okay. Somebody's asked, is our website address law4yourwebsite.com or law4websites.info? Okay, what we're doing is law4websites.info is a legal information pack website. So you can buy a whole heap of legal forms on that website. Law4yourwebsite.com is my business website. It's got a whole lot of information, blogs, articles, bits and pieces, things like that, but it doesn't actually have any products on it anymore. What we've done is separated them both out. So one's sort of a legal forms publication website and the other one's a blog website. So we actually have both of them. They are both ours, but the one that we've been talking about today is law4websites.info. So thanks for that question, Tom. Will I be doing another webinar? I'm happy to do another webinar. If you've got some specific questions or topics that you'd love to hear about, let me know. I regularly give presentations and talks. This is the first time I've done it via webinar. I have been interviewed on a number of webinars before, but as I say, this is the first one we've run ourselves. I've done talks on consumer protection, on contracts, on structures, on all sorts of stuff like that. If you're interested in hearing any of those things, then please do contact me and we can organise something for you. Do these changes apply to incorporated clubs is a question that's come through, and the answer is yes. The Privacy Act changes will now apply to any business, and they refer to entities and organisations. Entities include trusts, partnerships, all those sorts of things, including incorporated clubs. So yes, you will be covered. Okay, somebody's popped up and said they want another webinar. Fabulous. Okay, well, thank you all very much. I really appreciate your time this evening. It's been great having you on board. By all means, feel free to send us an email, contact us, let us know anything else you'd like to hear about, and we will definitely let you all know where the link is to the recording of tonight's webinar. And we've done it in time. How about that? Thanks very much, everybody, and good night.